How does State Question 805 apply to certain concerning felony crimes? I'm Tulsa attorney James Wirth. I'm doing a series of 7 videos discussing issues related to State Question 805. And this one addresses 3 of the particular crimes that you hear people in opposition concerned about. And the first one is domestic A and B by strangulation. So first off, violent offenses, which means that they are on a list of violent offenses listed by statute. Those crimes, they're not affected by State Question 805 at all. There are just crimes that are not on that list that are affected. So domestic A and B, assault and battery by strangulation, is one that is not included as a violent crime for the purposes of State Question 805, because that crime was not added to the violent crime list until November 1st of 2020, and State Question 805 goes by the definition list as of January 1st of 2020. So that means that State Question 805 is applicable to this crime. So if somebody is charged with domestic A and B by strangulation, the current range of punishment is 1 to 3 years. But with sentence enhancement for a second offense of that, the range of punishment goes to 3 to 10 years. Now, if somebody doesn't have a prior conviction for domestic A and B by strangulation, but has a prior conviction for something else, then the range of punishment, instead of being 1 to 3, oddly enough, is 0 to 10. But if you have 2 prior felony convictions, then that goes to 20 to life. So somebody who's convicted of domestic A and B by strangulation with 2 prior felony convictions, even if the felony convictions are just like larceny of merchandise from a retailer or possession of meth prior to the law making that a misdemeanor, then those are going to enhance it to where you have to serve a minimum of 20 years. That person has a minimum of 20-year sentence and a maximum of up to life. That's a very wide range of punishment, but it's a very stiff minimum. And it's important to note that, just because the title of the statute calls it by strangulation doesn't always mean that it's defined as strangulation. So in this case, it's interesting to note that when this goes before a jury to make the determination of whether the crime was committed or not, the jury instructions aren't going to actually require strangulation, because attempted strangulation is strangulation under the statute. So we've got to consider that as well, that under these circumstances, if somebody's got 2 prior felony drug offenses, and then within 10 years, the cops are called on them for domestic violence, where there's an allegation of strangulation, the jury doesn't have to find that there even was strangulation, only that it was attempted, and the minimum sentence, the jury cannot sentence them or recommend sentencing any less than 20 years. They've got to at least give them 20, but they have the opportunity to recommend up to life. So if State Question 805 passes, that goes away. The maximum sentence is 1 to 3 years. And I can tell you, as handling criminal defense representation as well as representing victims, that it's very rare that people get the maximum sentence. So the fact that sentence enhancement goes away doesn't necessarily mean these people are going to get lighter sentences. The range of punishment may go down, but because they're not usually getting the high end of the sentence anyway, their sentence may still stay the same, but that's going to be on a case-by-case basis. So that deals with domestic A and B by strangulation. Okay, next one people have concerns about is DUI with great bodily injury, and that is not on the violent crime list. Has never been on the violent crime list, and the regular range of punishment for that is 4 to 20 years. So for a first offense, no priors, that's 4 to 20 years. Now, right now, without 805, if you have a prior felony conviction, no matter what that prior felony conviction is, that minimum doubles and it goes up to 8, and the maximum goes from 20 to life. So minimum of 8 years for a DUI with great bodily injury. If you have 2 prior felony convictions, then that minimum triples to 12. And it's still a maximum of life sentence. So that's a pretty hefty sentence, in my opinion, for, although obviously a bad crime with a tragic result, is not somebody who was necessarily intentionally harming somebody. But that's something that has to be considered when you decide how you want to vote on State Question 805. The other one deals with sexual battery. And that is not a violent offense that's on the statutory list. So it is affected by State Question 805. And right now, what the law says is the range of punishment is 0 to 10. With 805 for a first offense with no priors, it would still be 0 to 10. But if you have 1 prior felony conviction, it goes to a range of punishment of 2 to life, all the way to life. It goes from a maximum of 10 years to a maximum of life sentence if you have 1 prior felony conviction, no matter what that prior felony conviction is. And then if you have 2 prior felony convictions, it goes 4 to life. And I recall one case where I had a client who had a bail bondsman, and he grabbed her bottom and then was charged with sexual battery. So that is an example of what a sexual battery is. It's just, grabbing somebody, and obviously we don't want that kind of behavior, and we want that kind of behavior punished. But we have to consider also what is the cost to society of incarcerating somebody. And the financial cost, about $16,500 per year, but it's also a loss of productivity by having that person incarcerated. It also affects that person's family, that person's kids, all of those circumstances, and those have to be thought about. And so for that crime of grabbing someone's butt without permission, is 10-year sentence not sufficient? Because if a 10-year sentence is sufficient for that in all cases, then you don't have to worry about State Question 805. But if you think that you want the jury to have the ability to go all the way to life incarceration, then you may not want to vote for State Question 805, because that'll put the maximum sentence at the regular sentence for a first offense, which is the 0 to 10. So hopefully that answers your questions on how 805 would affect various circumstances. If you still have questions about that, we do have attorneys that answers questions all day long. So if you want to talk to somebody in my office, you can go to makelaweasy.com.